Welcome to the latest episode of the Ansons and Solicitors podcast. I'm joined once again by my colleague Jason Alcock, who's the head of our employment department. Today we are going to discuss why it's not illegal to provide a bad reference. We're going to deal with the thorny issue of settlement agreements, and finally we're going to tackle the costs of employment law. Jason, common line that gets said to me by both employers and employee clients is that it's illegal to give a bad reference. Is that true?
No. So you can give a reference and you can put in it whatever you want to within reason, provided that what is in there is true and not misleading. So, for example, if an employee has been dismissed, you're free to put a line in the reference that says that they have been dismissed. But there's a fine line there. You've got to be very careful when you're drafting them, in the sense that you don't want to say anything that is untrue or that's defamatory, because you might find yourself on the back end of a defamation case if you're not careful.
So that's the key here, isn't it? Is that if the risk that you've got is the law of defamation, and defamation, typically what you think about here is when a newspaper says something bad about a celebrity, implies something about a celebrity, and you'll hear that the celebrity's gone off to some QC or KC these days to file a writ to sue them. But it's the same law that is used if an employer gives a bad reference about an employee.
Absolutely. It's a statement to a third party that's implying something that's untrue or misleading.
And likely to, lead to them their character being impugned or being thought ill of.
Yeah, and I guess to a degree, though, in an employment context, it's probably slightly easier in the case because you're going to be able to show loss, because the person's going to have used that or tried to use that reference to get a job and won't have got the job because of the bad reference. So if it is a defamation type claim, then they're going to get over that hurdle.
Well, especially because often somebody will have offered somebody a job, made the offer, take up the references. They then find that the employer or the previous employer has given a bad reference, and then may pull their offer. They can literally say, well, I would have had this job.
Absolutely.
So in that regard then, whilst an employer is free to say whatever they want, they've got freedom of speech, the general advice from us to an employer is what? Keep it factual?
Yeah, keep it factual. If you're concerned, take some advice on it beforehand. It's a reason why many employers today will only give dates of employment, last job, sometimes reason for leaving, if the reason's, something relatively uncontroversial, redundancy or resignation, or and the advantage to that is that you just can't get yourself sued because it's factual, it's there, you've got a complete defence of truth, and also where's the negative comment. So if you're trying to stay out of trouble,
don't use adjectives.
Yeah.
Just a load of statements that say, and I see that all the time as somebody who also employs people, that what their job title was, the dates of employment, and often doesn't even say reason for leaving.
Yeah, absolutely. And it's the same reason why if you get questionnaires through, people won't always answer them. They don't have to. Just so that we sort of cover off all of that, of course, you don't have to give a reference. There is no rule that says you must give a reference. So if employers are uncomfortable and they don't want to give a reference, they can refuse. In most cases, why would you? Not just give a factual if you're concerned, but if you really wanted to make a point, don't give one at all.
Yeah, there are some slight exceptions to that. I do believe in certain education and social care, the code of conduct within the industry or the sector generally is that you are expected to give a reference, and actually to you're still going to be careful as the employer, but to give details because they're worried about from the safeguarding angle as much as anything else.
That's right. And so, for example, teaching, they have to, if there's a capability issue, or a safeguarding issue, they've got to include that within the detail. But also the financial services, they also have statutory requirements that full references are given, and you can't back out of those. But generally, for most people, they don't apply.
If you are an employee and you want to go back to your employer and you want to try and get something more than the dates of employment, what advice would you give to an employee there try and coax? Just charm school, is it? Or
No, I think if you keep it factual, you're far more likely to get some leverage there. So, for example, if you're saying, well, can I have something in it that says my job includes X, Y, and Z roles? If you've got some awards that you've won and you're recognised for, then try and include those. It's all factual
promotions
statements.
that you've got over the time that you were there.
Yeah, absolutely. The employer doesn't have to, but again, you're not asking them to make a statement. You're not asking them to say X, Y, and Z is brilliant. You're asking them just to say, look, this is what their job was. Yes, there's been a promotion. Yes, they've got these awards. And with things like awards, you could probably show them anyway. So you're not asking them to give an opinion. You're not asking them to make a statement that could potentially be untrue. You're just asking them to give the facts, and it gives you a little bit more as an employee then as well.
I think I'm getting up to the references that I see. You're getting up to sort of 80 or 90% of them are just factual. However, of course, it's not. That's probably not a good sample for the rest of the economy, because most of the people that references that I'm taking up that are lawyers or that worked for a law firm previously, so lawyers are drafting them and are being very sort of mealy-mouthed in terms of the references that they're writing.
To be honest, I think it's probably
same across the board.
Same across the board. Most that I see in any form, and don't get me wrong, we see them in a fairly limited spectrum, but I think they are factual, and certainly when working with some of our clients, you can see that they've got policies that says all we will give is a factual reference.
Have you been involved, and we won't be able to give much details, but have you been involved in some cases where the reference that has been given has been horrendous and that's caused a dispute to occur?
I have. I've had two. One where there was a horrendous reference and that wasn't entirely true, and we had an argument about it. And we did and I'm not going to go into any real detail on it, but we ended up with a settlement at the end of it. And
where the employer had to pay for writing that, writing a bad reference, yeah.
It wasn't so much about paying for what had been done, but more for agreeing what was going to be put in future, so that we didn't end up with the same position. One that I did have, and which was a really unique one, and this will sort of dovetail into what we're going to talk about in a moment. I had one where we'd agreed a reference as part of a settlement agreement, and then the employer decided that they didn't want to give that reference after all, and they were going to give something very, very different. And
so stop there. The employer has entered into a settlement agreement where they've contractually agreed what they're going to say.
Yeah.
Only then when the reference request comes in to say something completely different.
Yeah, absolutely. And this is one of the few times where if you've agreed something, you are going to be bound by it.
You're contractually obliged to say it.
Yeah. And if they were to breach that, then they can be injuncted and they can be sued for damages for breaching. And in that case, it was something simple, like there was a settlement agreement, they'd come to a conclusion, and the employee on the way out had made some horrible comment about what they could do with the job and the orifice they could shove it up.
Yeah.
And then when
That's very nicely put for a family podcast.
Yeah, I'm trying to be PC.
Yeah.
But then after the event, settlement agreement's already in place, the employer just puts a line on the bottom of this reference, which is all the agreed one, but with this one line that says, this person's a right so-and-so, just so you're aware, they told me what I could do with my job after signing at the end of it, sort of thing. And we had quite a bit of fun and games with that one, because although it was all true, you'd have a complete defence in defamation, it was actually a breach of contract, because fundamentally
they'd agreed to say one thing and they've said something else.
Yeah, absolutely. So we do see them. They're not, the reference disputes are not always that clear, not always that obvious, not always one of the sort of main things we deal with, but we do see them from time to time.
And so the point is, so the common thing that gets expressed again by both employers and employees is that it's illegal to give a bad reference.
Well,
actually, the moral of the story is, no, it's not. But if you're a sensible employer, you're probably giving a very factual reference and not saying much more than that.
Yeah, absolutely. Now, you also might sort of move away from that if you've got a very, very good employee that you've had for a long time and you want to be a bit more supportive. But again, the advice from us as lawyers is always going to be, well, don't pass your opinions. Just give them more by putting the factual stuff in. That will often be more than sufficient for what they need, and you both stay out.
And then finally, just from an employer's perspective, we should have a policy on references and a person or a job title to whom those references are provided.
Absolutely. And this is something we've seen on several occasions. I think even we've seen it in Ansons, and we've got a policy for it. And that's where you can end up with somebody leaving and trying to give somebody else as a referee, who might be a friend, might be a colleague,
but just has got no, isn't in on the law on, if you're a conveyancing solicitor, you don't know the pitfalls of defamation law, I wouldn't have thought, and shouldn't really be giving, the firm's references.
Absolutely. And equally, these people might not be able to comment on anything, so why would you want somebody that was junior commenting on somebody's work when they may not have even worked together in that department, or be able to comment on what that person's work's like?
Golden rule: have a policy, stick to it.
Yeah.
And you didn't mention risk assessment, which I think is positive. It seems like you've already prejudged the risk assessment on that one.
I don't think there's a risk assessment necessary in this one. I think we can get away with that one.
No, fine. You mentioned in that discussion the settlement agreements.
Yes.
First question. This has gone by a couple of names over the years, actually, in my career. But what is a settlement agreement?
Okay. So a settlement agreement, formerly called a compromise agreement. Don't worry about the name of it. It does exactly the same as it used to, just a different name that was changed probably 10 years ago.
Yeah, I'll say.
Effectively, it's one of only two ways that you can settle off any claims in an employment forum. It's an agreement that's in writing between the employee and the employer. It's settling any claims they've got at the point in time that they're entering into it. And the thing that's slightly unique about them is that the employee has to have employment law advice from a qualified solicitor or barrister or trade union official that's certified to be able to give advice on that.
And just to pick up on that, I mean, there's some logic behind that. Is, of course, employees and employers are used to signing contracts. What the law, when they put all of these laws in place, employment law protections from the National Minimum Wage Act, unfair dismissal, be very easy for an employer to put a line in the contract or a letter for their employee to sign saying, I waive my right to the national minimum wage, or I waive my right to bring an unfair dismissal claim. And then when they do need to bring a claim in that regard, have the employer shove that piece of paper in their face. And the intention was that, having introduced all of these pieces of employment legislation, that the employee could not readily waive those rights. They could only do so in the context of a settlement agreement, whereby they are required to obtain some form of official employment law advice.
Yeah, exactly. And so that then they also know exactly what they've signed up to, because our job, if we're ever advising the employees, is to tell them what's in it and what it does and how it affects. And in particular, it's how their rights before an employment tribunal are affected by this document, i.e. they're signing them all off. They're not going to be able to bring them. It's a barrier to a claim. And often linked to that, then you often get the question of, well, is this good, bad, or indifferent? And you're then looking at it from the employee's perspective and saying, well, look, you could win more, or in some cases, look, this is a brilliant agreement. You're never going to win more, so snap the hand off. So, but the employee knows then when they're signing up to it, A, what it's doing, and 95% of the time, whether it's a reasonable deal or not.
So typically this is a document that's about 12 or 15 pages long. It starts off with the employers and the employees' name and addresses and a load of definitions. And then the good bit from the employee's perspective is normally contained in clause 1 and 2, which is what notice pay they're going to be getting. And normally, or often, a termination payment on top of that.
Yeah, absolutely.
The rest of the agreement, in some respects, is what the employer is getting out of it. And I always say that, with some exceptions, but what the employer is getting out of it is the certainty that they don't have any claims, that once this document has been signed off, that the employment relationship has been ended and they don't need to be looking over their shoulder, that they're going to be presented with a tribunal or other claim in the future.
Yeah, absolutely. And the only few claims that then stand outside of that will usually be the enforcement of the agreement. It'll be the accrued pension rights and any personal injury that's not yet in play. And
an employer couldn't, if you'd got something, heaven forbid, like a asbestosis or repetitive strain injury, which only emerged many years after you'd signed that contract, the employer or the employer's insurer, perhaps more likely, couldn't hold up the agreement and say, oh, you settled your redundancy claim 10 years ago, I'm not paying out your compensation for, one of these ailments.
Yeah, absolutely. But there is that point, and one of the things that employees should be aware of is if they've got anything ongoing, then they should be jumping up and down, and they should be saying, hang on a minute, I'm not settling that claim, which is already there. And that needs to be carved out separately.
Yeah, I always liken that. And when I've got an employee before me, I will always say to the employee, this is a bit like the part of the wedding where the priest or the vicar says, speak now or forever hold your peace. You need to tell me, what some of the problems or even potential legal claims that you've got, so I can advise you on them and up to a point, to a certain extent, to see whether what they are offering you is reasonable. It's not quite for us to get into a commercial assessment of that, but certainly to do our job properly as a solicitor, if we felt that an employee was getting ripped off, we need to make sure that they know that doesn't seem like the right kind of compensation for given their length of service or their seniority or how they've been treated within the organisation.
Yeah, and I've had a couple of circumstances where I've been sat with somebody and said, well, have you got anything else? No. And I had one guy who came in with a cast on his arm and happened to say,
What about that?
What about that? Notice you've got, looks like you've hurt yourself. Was that outside of work? Oh, no, I dropped a weight on it last week. I'm like, well, have you got a claim going on? Oh, I've told my insurer, I've told my union and they're pursuing it for me. Right, okay. Well, we haven't carved that out. We need to carve that out specifically so you don't run over it and stop it as part of a redundancy exercise.
The other one that I've seen actually is bonus related, and the fact that on occasions an employee has come back to me and said, I don't know, say 6 months if they left at Christmas and then bonus gets paid after the end of the financial year, and they come to me and oh, by the way, I didn't get my bonus, and of course, virtually always the settlement agreement will say, that's it. What you're getting in this settlement agreement is what we're offering you, nothing more. So if you are due things like bonuses, it's a point of negotiation then. But if you are due things like bonuses, you need to say that to your solicitor or legal advisor so they can ask the employer about that and perhaps try and get some form of compensation for the fact that they may lose that bonus.
Yeah, 90% of the time it'll be a discretionary bonus, so you probably can't do anything with it. But every now and again you do get some. Or sometimes if you've got an employer that's desperate to get rid of a certain employee, they might be more willing to put a bit more in and to sweeten that deal so that they'll go more easily. Okay,
so here's a myth from the settlement agreement. I can have the first 30,000 tax free. Can I?
Sort of.
Kind of, yeah.
So you can have up to £30,000 tax free, provided that it is a true ex gratia payment.
Hang on, Jason, picking you up on Latin here. A payment that you don't have to pay. It's like a settlement payment.
Yeah, so it's a payment where there is no tax payable to it.
Yeah.
And what you're looking for is something that is not contractual and something that there is no other ties in the employment relationship to. So, for example, I've seen employers try to put a payment in lieu of notice in there. Well, very sorry, it's a payment in lieu of notice. That
comes from the contract, therefore it's subject to income tax.
Yeah, absolutely. I've seen them try to put holiday in there. Again, comes from the contract. You'd always have to pay tax on it. You can't just call it an ex gratia payment. Or
bonus,
another good example. And I've seen this, and sometimes I've seen bonuses put into the settlement as tax-free, and the chances are the revenue probably won't take too kindly to that. The other one that sometimes will go in there is if there are new restrictions and there's a new restricted covenant being added and the employer is paying something for that, they might say, oh, look,
I'm not going to compete with you for 6 months or 12 months or whatever.
Yeah. And in return for that, the employer might pay them, might be a nominal figure, it might be £1, it might be £100, it might be £1,000, it might be more. But they put that in the tax-free element. Problem with that is it's not tax-free.
So you've done a very good job, again, very loyally off you saying what it's not. What it tends to be sort of redundant, a payment that's akin to a redundancy payment can be, or a redundancy payment can be paid tax-free up to £30,000.
Yep.
And also, in effect, when somebody's, it's akin to a compensatory payment or a golden handshake that they're not contractually obliged to make, but isn't something that the employee is contractually entitled to.
That's right. And usually employers, that's the thing the employer is willing to pay to get them to enter into the settlement agreement. Because without it, what's the purpose, what's the point from the employee? And there's an argument if you've got a payment in lieu notice rather than being made work your notice period, in the sense that
there's a benefit to be able to sit at home and watch Homes Under the Hammer.
Yeah.
For 3 months.
But with some of them, they might be working the notice period. But financially, they're in exactly the same boat. So the ex gratia is the
terminal. I'm going to stop you using ex gratia.
The settlement payment is the bit that's the over and above. It's the thing,
cherry on the top of the cake.
It's the thing that the employee could lose if they don't sign the settlement agreement. It's the money they're going to get that they wouldn't be entitled to.
So, and how most settlement agreements are structured, the bit that there is tax upon is set out first. So in other words, it's dealing with the rest of the contractual relationship. So are you going to be paid in lieu of notice, or are you going to work your notice? How many accrued holidays have you got left that you have to take or are going to be compensated for? If you are compensated for those days, they are subject to tax. Might deal with bonuses, might deal with pension contributions pre-termination. Then typically there is the clause that deals with the termination payment, the ex gratia payment, as you keep calling it.
Yep.
I'm going to keep taking the mickey about that. And there's also normally what we call a tax indemnity on there, which says if there is any tax to be payable on this employee, you're the one who's got to pay that tax, at least the employee tax element of it, the income tax and employees' national insurance.
Yeah, that's right. And you need to make sure that that is tied down so that it only includes those sums.
We will then see in this contract a waiver. And this, in some respects, I always think there's a bit of bad drafting here by us lawyers. We will often then go and list, whether in the main agreement or at the end of the agreement, every single possible claim they could ever bring. Mm-hmm. From European trans-border consultation obligations to when the employee works in Cannock, the company's only based in Cannock and there's no trans-border element at all. But they're all listed, are they not?
They are, yeah.
But then it also says, even if they're not listed, it's everything else you could possibly bring as well.
Absolutely. Now, what you might see, and if an employee's looking at it, or even if an employer's looking at it, they might see two clauses. They might see one that says, you're getting rid of all the claims in Schedule 1, and that's the long list as long as you're on.
Yeah.
You might then get a second clause that says, but specifically, you're getting rid of these claims. And the reason for that is the way the legislation's drafted, and it says it's got to somewhere say the claims that you've got and you're getting rid of.
You might most likely to bring.
Yeah. And that's just narrowing it down, and that's making sure it complies with the legislation. In reality, what's the document doing? It's getting rid of any claim you possibly could have, other than those few that are exempt.
Have you ever seen an American version of one of these things? Because I have, and it had a brilliant form of wording in it that said any claim from the beginning of the earth till the end of time. So it's trying to cover everything. Actually, ironically, an English settlement agreement, you can't cover future claims.
I'm not sure that's entirely right, because there was a case a few years ago that got up to the Lords, and what the sort of obiter from it, what the commentary from one of the judges was in this.
Jason just used some Latin there, by the way, again. So just for the audience,
it's that one of the judges said that the general rule was, well, you can't get rid of claims in the future. And one of the judges turns around and says, well, that's not entirely fair or true. There is no reason that you can't get rid of future claims, provided that the settlement agreement is sufficiently clear as to what claims you're getting rid of. The problem is he then bloody well stopped. So he didn't go on and say, to be sufficiently clear, it needs to do this.
It needs to say this.
Yeah. So we've now got this position of, well, could you get rid of future claims? Maybe. The rule, and what I always say to any client is, look, if you're going to sign a settlement agreement, don't worry too much about the future claims. But if something comes out and you think you've got a claim, before you go to your employer, or former employer as it probably will be, come and talk to a lawyer, come and talk to somebody, tell them about the settlement agreement, tell them about the facts, and we can decide whether or not it has gone or whether there might be a bit of an argument.
Yeah, I mean, let's be clear here. It typically ends the employment relationship. Once the employment relationship is ended, the chances of them having a future claim are remote, but I guess it's theoretically possible. I mean, what I do see a lot of when there's a long notice period, settlement agreement might be signed in on the 1st of September, but they're due to work their notice period and the termination date may be the end of the year. It's now quite common for there to be what's called a reaffirmation certificate. How does that work?
So the settlement agreement kills all the claims to the point that they sign, and the reaffirmation agreement's effectively a mini settlement that affirms what was in it, but it kills the claims between the point the settlement agreement's signed and the point they leave their employment. So it means that when they do leave, it's both parties going separate ways completely.
Another common clause that employees point out to me and don't or naturally balk at is there's often a clause about confidentiality.
Yep.
And there's often a clause that mentions non-derogatory remarks, which is an anti-slagging off clause or a gagging clause in effect. They're typical clauses, right? The employee doesn't need to...
No, the employee doesn't need to worry about them. They're standard, they're in. Largely, they're just there so that the whole point of the settlement agreement is to give a clean break between the two, and so that the employee isn't going to run around making adverse comments, derogatory comments. But I wouldn't worry overly about them. And further, it's only stopping the employee from going off and making a comment down the pub or on social media about the
Well, that is the slight difference from years ago when these would be signed, that, you know, an employee has got, with social media, with review websites, has got the opportunity perhaps to publish a comment that was derogatory about their employee with the money safely in the bag. And it's quite common in the settlement agreement for, if you were to breach a clause of the settlement agreement, that the termination payment is repayable. I know that can be negotiated. But I think that clearly what we will be saying to most of our employee clients is once they've signed one of these documents to keep still.
Pretty much. The only thing to sort of take out of that is that documents now will normally have something in that says it's not stopping you making protected disclosures. Yeah. It's not stopping you from going to, for example, if you've seen a crime being committed, you can go to the police or the fraud squad. It's not stopping you reporting things to the HMRC. It's not stopping you from reporting anything that's regulatory. So, for example, if we as solicitors were doing something wrong, you can't use a settlement agreement as a way to gag that and prevent that coming out. You've got to use it as it stops the claim that might be there, but it doesn't stop the misconduct from being
often described as a whistleblowing disclosure.
A whistleblowing disclosure. Yeah. Exactly that. But so it's not quite you can never say anything negative about this company or this employer ever in the future. It's saying you can't do it outside of what you're allowed to do and what you might be required to do.
Normally, the clause will allow the employee to share some details around their termination with their future employers, their husband and wife, the authorities, their legal advisors. That's quite common.
That's normal. Yeah.
But they don't necessarily want you walking back onto the shop floor or back to your fellow colleagues or former colleagues and saying, "Oh, I got this big payout," and that's what it's there to prevent from occurring, really.
Absolutely. And equally, and some employees don't always appreciate that, it often cuts both ways. So often it's the employee saying, "Well, I'm not going to say anything bad about you," but the employer saying, "But I won't authorise or make any bad comments about you either."
It's mutual.
So it's mutual.
Then one of the final points that I would have to make is, which is important, typically who pays for the legal advice that the employee is required to obtain?
So normally the employer will make a contribution. There's sadly nothing in legislation that says they have to, but it's a convention that's come about over time. And fundamentally, the employer wants the employee to sign off on the settlement agreement because they get the benefit of the protection under it.
Typically, the contribution historically for many years, and no one gets the violin out for solicitors, it didn't change for like the first 15 years of my career. It was always £250 plus VAT. It seems to have gone up a little bit more recently.
It has moved a little bit. It tends to now be somewhere between £350 and £500. Interestingly, there was a case on this actually with a university where it got before the EAT when a claim got
Employment Appeals Tribunal.
Employment Appeals Tribunal. And there was a point in it where a settlement agreement had been offered, but it was never taken. And then when one of the grounds that got onto the claim was that the employer was unreasonable in this. And I think it's the only case where the tribunals had a chance to look at settlement agreement fees and make any comment. And in that one, they had £500. And what the tribunal seemed to be saying was it was reasonable if all the solicitor was going to do was to advise us to the settlement agreement, but it wasn't reasonable in that case because of the fact they were asking them to advise on the claim, the merits of the claim, and the settlement agreement.
Well, that's a very pro-lawyer bit of judgment, isn't it?
It is, but the problem is we've got no law that pins underneath it.
Yeah, but actually, I mean, there's some good common sense to that because I think for the most part, what we would say is to take you through the settlement agreement. I mean, sometimes it's high risk if the numbers are really large, but the sort of conventional figures, we can normally provide the advice for the contribution. Most of the time, we don't charge employees anything more than the employer is being
Absolutely.
Charged. And if sometimes it is going to require more than that, our first port of call will be to go to the employer and say, look, this is insufficient. Can you increase your contribution? Again, not most of the time, but a lot of the time the employer will increase their contribution.
Yeah, usually they will be fairly amicable to it, although equally I have come across them and I've seen it where employees have been unreasonable and we've just said, no, we've made a fair contribution, we're not moving. And the problem you've got there is the employee just has to take a call. It becomes a commercial decision, not a legal one.
We dealt a lot with this from the employee's perspective. Why would you use a settlement agreement if you're an employer?
From the employer's perspective, it's a complete break, same as it is for an employee. And it removes potential problems, and it means that once that is signed, that's the end of it. The employee can't bring a claim, and you can go your own separate ways. And the advantage to it is if you've got that, employment litigation can be expensive.
Yeah.
And what you're doing is you're forcing the hand early so that you can try and reach a settlement and you know what your exposure is, you know where you are and you know where you stand.
Employment tribunals in particular take a long time to conclude,
Yeah.
take a long time to get listed. Even normally, I mean, there are certain limited exceptions to this, but for the most part, even if you win as the employer, you don't get your legal cost back. You have to bear those costs yourself. You can win and spend tens of thousands of pounds defending an employment tribunal, and that will be a loss to you.
Absolutely.
And using a settlement agreement will prevent it from going there.
Yeah, stops it ever happening, and it means that you've got peace of mind. And you can get extra bits into the settlement agreement that you won't get if you're going off to the ET. You know, we've talked about the confidentiality provisions. We've talked about not the gagging clauses, but the non-derogatory remarks. You're tying everything down pretty swiftly and pretty easily. And that just gives you a greater protection. If you want to as an employer, I wouldn't always go for this route, but you might want some restrictions. And if you've got a person that's been with you for a long time, that's come in as a junior, you've promoted them, but you may not have updated their contracts, they might be privy to a lot of information. You might want some restricted covenants in there. You can bring those into a settlement agreement and give yourself extra protections. Yes, it might cost you. Yes, you might have to have some sort of negotiation around it, but it does give you a bit of extra power, or not power, but control over it, and the chance to bring those in. So it can be even more advantageous. It's not just stopping the potential claims.
Well, if you are out there and you're watching this and you need some advice on a settlement agreement, if you're an employee, we can help. And also if you're an employer who's facing maybe a claim or deciding to terminate an employee's employment contract and considering using a settlement agreement, again, we can help. Let's talk costs. Let me try and pin you down a little bit. So firstly, if you are an employer and you want an employment contract draft in, what would we typically charge? Or give me the range at the very least.
If it's a very, very junior one, you'll probably be looking at an hour's work of one of our juniors, so you're probably looking at about 250 quid. If you're looking at a very senior, complex contract for, say, a director, you're probably looking somewhere between £1,000 and £1,500 to draft them. But it really does depend. Sometimes we'll have, directors that people don't want to have all singing, all dancing contracts. They just want to do the minimum to protect. So that effect. And
one of the services that we offer, which I think is important to mention, is we've got what we call Ansons Encore, which is a fixed fee retainer. I'm always going to liken it to the Chinese buffet restaurant. It's all you can eat. We will typically charge, dependent on the number of employees, but our median price is around £2,500 per year. What do they get for that?
So within that, we'd review contracts. We'd provide new contracts if they want to. We'll review staff handbooks if they've got them, or we'll put a new handbook in place. And the new handbook could be dragging in policies that they've already got, or it could be completely new. And then we offer the advice line that sits with it, and that's to myself, to you, to one of our solicitors, and that's unlimited. And that's to assist with any problems that might come up.
They can ring us up without worrying that the clock is ticking and they're facing the hourly rate.
Exactly. And that could be to deal with all sorts of things. We get it for disciplinaries, we get it for grievances, we get it just sometimes for oh God, I've got this potential issue on the horizon, how do I deal with it? So it could be a redundancy, it could be I'm thinking of selling my business. It could be a whole manner of things.
And also they get access to a suite of documents that they can directly access on the internet if they're on the On-Call service to help them with, a disciplinary process or something along the line.
Right. So we've got the document library. That's relatively new. That's something we've completed and got up and running in the last 12 months. And within that, it's got various sections. So we've broken it down to documents that you might want if you're dealing with a specific problem. And they're all in sort of very easy to find, easy to follow areas. And that includes, I've used the example already, the disciplinaries. There's a series of letters as to how to conduct one and which one you need for each step. There is on there the same for the grievances. There is the same for flexible working requests. And to go with those, we've started to put up a series of fact sheets, if you like, where you might not want to necessarily talk it through with one of us, but you might want to have an overview as to what it is, or you might want a refresher. So it's just a pretty straightforward document that you can have a look at and go, okay, so to do a disciplinary, first I must send letter 1, then I have the meeting, and at the end of the during the meeting, I'll sort of have these things, and these are the questions that I will have to ask at the end. Then I'll have letter 2, which is the outcome, and the opportunity for an appeal and how the appeal works, and then letter 3 for the outcome of the appeal. So it's all designed to be very user-friendly, but one of the things that we're not saying to anybody is, there's the document suite, don't talk to us. It's very much
we'll help you.
It's we're here to help, and that some people really want us involved. Some people might want to have a look at the documents and have a think about them before they talk to us.
And run the draft past us before it goes out.
Exactly.
I think it works better, actually, typically, if an employer is in control of the document themselves and then we're tweaking it to help them.
Yeah.
In terms of an employment tribunal and the cost of an employment tribunal, I appreciate that this is how long is a piece of string. Mm-hmm. From the employer's perspective, unfair dismissal, let's say it's scheduled to be heard over 2 days. What would the cost, taking it all the way to that final tribunal cost?
All the way through. If it's listed for 2 days, and unfair dismissal claims seem to be listed for 2 days, a lot these days. When I started practicing, it was always unfair dismissals are 1 day, but they seem to have expanded that.
Yeah, hence why I asked a question like that, Jason.
Fair enough. But I would expect the cost to be somewhere between probably about £5,000 and £12,000. Yeah. But that's not to say it would always be that, because sometimes there are extra bits in.
And why the big range, though, 5 to 12? That's quite a big range.
It depends on what you've got. I mean, you could have a case where there are 2 witnesses, and in which case there's very little in terms. There's still a lot of work to do, but there's very little in terms of witness statements to prepare.
Yeah.
And you can get other cases where you might have 10 witnesses on either side.
Yeah.
And so you've got a lot of witness statements to draft, a lot of witness statements, evidence to read. You might have lots of documents that are in. And
a case can be document heavy.
It can. And some you'll have, 2,000 page tribunal bundles. Others you might have 50. It really does depend. It's fact specific, and it depends on what the issue is that's caused it all.
From the employee perspective,
yeah,
are those costs similar if you were using a lawyer to pursue an unfair dismissal claim?
Yeah, they will be. Now, the only thing you might have from an employee perspective is some firms, and we don't typically, but some firms might offer no win, no fee type arrangements.
Yeah, where you share effectively contingent arrangements where you share the damages.
Yes, what are now called damage-based agreements, and the lawyer can take up to 33% of the sums you win, effectively. And some firms will do that. You will see some that play that way, but many won't.
And in terms of from the employee's perspective, the employment tribunal are set up to be a forum that an employee can bring their own claim without lawyers being involved.
Absolutely. I mean, that's where the costs rules stem from. And the whole point is that Joe Bloggs can go to the tribunal on their own and put their claim forward and can have a judge hear it. Of course, that has changed, and what we've actually ended up with is a forum which is a form of a court, and it's got its own set of rules. The tribunal rules are quite lengthy and quite complex, and it's not always that straightforward. But if an individual wants to present their own case, they're free to do so.
And the other thing that I would always say, and indeed we're duty bound to say to all employees, is that you will often have legal expenses insurance covered by in particular your home insurance, that specifically covers you for employment claims, and they will typically have a panel of solicitors and they will act for you in that claim. So you don't have the prohibitive cost that potentially could discourage an employee from bringing a claim.
Yeah, I would widen that actually out from there. And I always say to employer clients as well, have you got any insurance policies? Because sometimes they've got things that are in there that they don't even realise is there. There's some protection, some cover, and that can be really helpful. One of the biggest cases I've ever run was a discrimination case. Unfortunately, the employer had the insurance on what was otherwise an 8-day trial. That the costs were significant, to put it without wanting to disclose any sort of details, but it was a long trial. It was with a very, very difficult claimant who at one point had got something like 30 different claims he was trying to run, and we were running tens of thousands of pounds worth of legal costs. So I wouldn't just put it down to just employees. And the other thing with insurance is you've mentioned that the insurers will have panels of their own solicitors. There's actually a piece of legislation that says the insurers can't just push it to their panel. Once the claim is issued, it's your freedom
you've
of
just
choice.
identified the slightly technical point there. So in an employment tribunal, it's once the claim has commenced, I guess.
It is. So they might not cover the pre-work, and they might not cover the drafting of the claim form, but once the claim is issued, you've got freedom of choice of your lawyer.
Yeah, and the only caveat or thing that I would say in relation to that is we would still say go to your insurers at the early stage. You can sometimes fall into the trap of the insurer then saying, well, you should have told me about this when you got a claim. If you've used your own lawyer to deal with the pre-action bits, at that stage you should also have told us.
Yes.
What you can say to your insurer is, I want to use my lawyer, I'm going to pay for the it before the tribunal is started, but once the tribunal starts,
Yep.
and
Absolutely.
that is something that you're free to do, but there is a trap there to avoid with the insurers if you're not careful. I mean, it would be a lot better if, in effect, the insurance position caught up with the intention of that law and the pre-action process was covered, and you had freedom to choose who your own lawyer was throughout that process. Unfortunately, that's not there at the moment.
No, it's not. But useful to know.